So in Illinois, in every one of these cases in which there's a child custody dispute, or what we call nowadays a dispute over parenting time and parenting responsibility, there will result from the case, at the end of the case, you'll have a 30-page, sometimes even much longer, allocation judgment. Why is it called an allocation judgment? Because it's a judgment or a court order that allocates between the parents parental time and responsibility. Now, all these factors that go into each of these aspects of parental authority are going to be fleshed out tremendously in this document so that there isn't even one remaining question regarding what do we do with regard to the parenting of our child after the divorce process. Everything from insurance to schools to doctors to childcare to religious services, maybe even dietary concerns are going to be included in this allocation judgment. Even things like sleep patterns, or sleep schedules, or way to handle the children with regard to their physical and mental health. All these things are going to be included in this allocation judgment. And it's extremely important in this process to make sure that you understand both the mental health consequences, the physical health consequences of every detail of this allocation judgment to ensure that the welfare of your children and your authority to facilitate and protect the welfare of your children for the rest of their lives, certainly until they're 18, but indeed, the consequence of this is the rest of their lives is going to be met and ensured and properly guaranteed as best as possible by this allocation judgment. How should one balance holidays and special occasions in the allocation judgment? So what tends to happen with regard to these allocation judgments is what happens also with regard to the marital settlement agreement, which are the financials in these cases, that each party has certain chips on the table, so to speak, things that they want, right? Things that they believe are in the best interest of the child that perhaps their spouse doesn't agree with. So regularly there's a negotiation that occurs in these cases, and one gives up certain things and the other gives up other things. And at the end of the day, often a holiday is given up in lieu of a special occasion of the other party. So the advice with regard to days that are extremely important to you is to really list them, to make sure your attorney knows exactly what it is that you absolutely have to have and what are things that you're willing to give up in the process, so that you make sure that ultimately this allocation judgment lists every single day, whether it's a holiday, whether it's a graduation, whatever it is, that you have the right to be there, that you have the hours and time that you expect to have and need to have with your child, so that you are doing everything you can to ensure that you have the maximum possible relationship, the best possible relationship for the best health and welfare of yourself and your child for years to come, that all those things are in this allocation judgment. So like anything in a divorce process, disagreements in whether it's the marital settlement agreement or the allocation judgment are things that can go either through mediation or through litigation. We've described in other videos in the series what's the difference between mediation and litigation, and I refer you to those to understand the particulars. But with regard to this aspect, I think it's extremely important to keep in mind that every battle over aspects of how to raise the child is likely to harm the child if these battles continue, all the more so after the divorce is over. So you want to make certain that the allocation judgment properly reflects something you're comfortable with, something that you know is going to be in the best interest of the children for the course of their lives. The other thing that often we do in these cases is we enter what's called a play nice order, where when these disagreements erupt over how to handle different aspects of dividing up the parenting time and responsibility, is we ensure that neither parent can disparage the other parent in front of the children, that neither parent can speak about the case in front of the children or otherwise cause unnecessary trauma to the children in the process of this dispute. Otherwise, they can suffer contempt of court for this improper behavior. So I tend to be in favor of a detailed parenting plan, which makes everything absolutely clear, particularly when the parents have unresolved emotional issues with regard to their ex, and they have maybe an axe to grind still in the case. In that case, it's essential to ensure that every single thing is clearly defined, because ambiguity will end you up right back in my office and right back in court, and that's what you don't want. You don't want to have to pay more attorney's fees. You don't want to have to spend more months stressed out in court. You want to ensure that, particularly where there is a disagreeable spouse, that everything is clearly defined so that it can be clearly enforced after court is over. Now, when you have a case where the two parties are very mature, professional, friendly, and they do get along, then flexibility can be allowed, right? Then I'm okay, for example, advising my clients to a certain amount of flexibility. But again, the risk of flexibility is ending up back in court unnecessarily. So wherever possible, I think it's good to have clear guidelines. This has been How to Create a Strong Parenting Plan by your attorneys at KHK Family Law. Friends, don't hesitate to reach out for your free consultation.